Good day, and thank you for watching. If you are facing criminal charges in California, there is a very strong chance your case will involve a plea bargain. In fact, most criminal cases are resolved through plea agreements rather than going to trial. But here's what you need to understand. A plea bargain is not just a shortcut. It is a critical decision that can affect your record, your rights, and your future. Let's start with the basics. A plea bargain is an agreement between the defense and the prosecution. In exchange for pleading guilty or no contest, the prosecution may reduce the charges, recommend a lighter sentence, or dismiss certain counts. On the surface, that can sound like a good deal. Less risk, less time, less uncertainty. But here's where many people make a mistake. They focus only on the immediate outcome. They look at avoiding jail time or resolving the case quickly without fully understanding the long-term consequences. Because once you accept a plea deal, that decision is final. You are giving up your right to a trial. You are accepting a conviction. And that conviction can affect employment, housing, professional licenses, and more. Now let's talk about timing. Plea offers can come early in a case, sometimes even at the arraignment stage. Other times they may be presented later after evidence has been reviewed. Here is the key point. The strength of a plea offer often depends on the strength of the case. If the prosecution believes they have strong evidence, the offer may be less favorable. If there are weaknesses in the case, the offer may improve. That is why understanding the evidence is so important. Before making any decision, you need to know what the prosecution has and what they can actually prove. Now let's discuss leverage. It's important to understand where it comes from. Leverage in a criminal case comes from multiple factors. The evidence and witness credibility, legal issues such as whether evidence was obtained properly, and the overall strength of the defense. If there are problems in the prosecution's case, that can create opportunities to negotiate a better outcome. But if those issues are not identified or raised, that leverage may be lost. This is where strategy comes in. A plea bargain should not be accepted just because it is offered. It should be evaluated based on the facts, the law, and the risks involved in going to trial. Now let's address risk. Every criminal case involves some degree of it. Every criminal case involves risk. This is a fundamental reality. If you go to trial, there is always the possibility of a conviction and potentially more severe penalties. A plea bargain can reduce that risk. It offers a degree of certainty, but it does not eliminate consequences. You must still be prepared. So the decision becomes a balance. You must weigh all the factors. Do you accept a certain outcome now? This is the primary question. Or do you take the risk of trial in hopes of a better result? There is no one-size-fits-all answer. Every situation is unique. Each case is different. The details and circumstances always vary. Each situation requires careful evaluation and strategic thinking. Another important factor is collateral consequences. Don't ignore them. These are the consequences that go beyond the immediate penalties. For example, certain convictions can affect immigration status. Others can limit job opportunities or result in the loss of professional licenses. Some may require registration requirements or other long-term obligations. These consequences are often overlooked by those in the situation, but they can be just as significant as the sentence itself. Now let's talk about pressure. It's a very real part of the process. It is common for individuals facing criminal charges to feel pressure to resolve the case quickly. The stress of the situation can be overwhelming for anyone involved. The impact on work and family is often a major concern for clients. All of these factors can lead someone to accept a plea without fully considering the implications. But this is not a decision that should be rushed or made lightly. Once a plea is entered, it is very difficult to undo. The decision is final. That is why it is critical to slow down, understand the offer, and evaluate all options. Now let's discuss preparation. It is the key to a better outcome. Even if a case is likely to resolve through a plea, preparation still matters. Reviewing evidence, identifying weaknesses, filing appropriate motions, all of these steps can influence the outcome of your negotiations. They can strengthen your position and improve the terms of a potential agreement. Without preparation, you may be negotiating from a position of weakness. Finally, let's talk about informed decisions. They are the best kind. A plea bargain is not inherently good or bad. It is a tool to be used. And like any tool, its value depends on how it is used. The key is making an informed decision. Understanding the charges, understanding the evidence, understanding the risks, and understanding the long-term impact. Because this is not just about resolving a case. It is about protecting your future. In conclusion, if you are facing criminal charges in California, take the time to understand the offer. Do not focus only on the short term. Look at the full picture and evaluate. Because the choices you make now can follow you for years to come. Choose wisely. Call us at 888-888-6582. I'm Vince Davis, and we are all in this together.